Hi there, it's Ron Gula from Gula Tech Adventures. In this week's episode on the Gula Tech Adventures YouTube channel, we are interviewing Danette Edwards, who is a former SEC attorney who's at Catton helping people sort of stay out of the crosshairs of the Securities and Exchange Commission. Danette, how are you?
Great. Nice to be here. Thanks for having me, Ron.
Can you tell us a little bit about your background? And you kind of switched from, I guess you could call it offense to defense?
That's right. I started on defense. So I've actually been practicing law for about 20 years. I started at another large law firm, a national law firm, where my first case out of law school, I was lucky enough to be on the criminal defense of one of the Enron executives who had been indicted for criminal securities fraud. I spent 8 years at that firm. Then I went to the SEC. I was part of the enforcement division there for my entire tenure. It was 12 years at the SEC. I was in a generalist group. That meant that all manner of securities fraud cases could cross my desk, insider trading, accounting fraud cases, big Ponzi schemes, auditor independence, you name it. And I investigated it and hopefully charged it. That was my mandate. And then a year and a half ago, I returned to the private sector. So you're right, I keep switching sides of the table, and now I'm on the defense side, helping companies and individuals navigate SEC enforcement and other government investigations. And
as a cyber professional, you know, I've been in this business about 30 years, right? We've always talked about the need for more government regulation. This administration's made a lot of big improvements, right? We got the Office of the National Cyber Director, but in your world, the SEC started weighing into cyber requirements for public and private companies. What's going on? We're recording this in May of 2024. What's the latest with the SEC and cyber right now?
So let's rewind. And there's big news as of a few days ago in terms of rulemaking at the SEC in cyber. But I guess last July, so July of 2023, many of your listeners probably heard that the SEC adopted public company disclosure rules for cybersecurity. So that covered the whole swath of the market. If you're a publicly traded company, you had to do certain reporting in the event of a material cyber attack or cyber breach, and then report on your report annually on your cyber security procedures. Fast forward to just a couple of days ago, and the SEC adopted final amendments to the safeguards rule, Reg SP, and that applies to a smaller slice of the market, broker-dealers, transfer agents, crowdfunding platforms, investment companies, and registered investment advisors, and it imposes certain obligations on them in terms of their protections for customer data, and when there is a particular misuse or intrusion on customer data, reporting obligations for the affected individuals.
So it puts a reporting obligation on the company, but if the company has got, their first-time CISO, not a great security history with that company, what implications are there for CISOs who are working at companies and now have to help people draft K-1s and, letters to the SEC?
So CISOs, I think, regardless of where you sit, certainly if you're at a public company, and some of these banks that would fall under the Reg SP amendments are also publicly traded companies. So they're thinking about a lot of things. They want to stay in compliance with SEC rules. And let's take it to you're in the middle of a breach. You want to decide if this is material. And if you're a publicly traded company, you got to decide, do I file an 8K? That's an extraordinary event reporting form. You do it in between your regular quarterly reports or your annual report. And so, there's a basic requirement that within 4 days of determining whether it's material, if you determine it's material, you need to report it to the world. And that's not just, an affected customer, like a breach notice. That's tell the world. And then, of course, you're thinking about if this is, very impactful and I'm at like a transfer agent or something like that, do I have to tell the customer? So you're going to be thinking about, hey, do we have an effective plan in place? What are we doing to respond to this breach? How can we assess it? Not only to meet our reporting obligations to all sorts of stakeholders, but just so that we can, respond without much delay, minimize consequences.
Now, we don't make the rules, right? We have opinions and stuff, but what are some of the arguments that might be against the SEC weighing these down? And what are some of the arguments that they should do this or possibly even do more?
I think whenever the government perceives a risk, they act. And that's going to be in the form of regulation and rulemaking like they've done here, but also in terms of enforcement. So rules, I think, provide at least some certainty, and it prevents what's called regulation by enforcement. So it gives people guideposts and ways to be transparent and tell investors and affected stakeholders about risks. And I think that's probably what the SEC's intention is here. So I think that's an argument for it. And it also prevents sort of hindsight type enforcement prosecutions.
Have you heard the argument that, this could have a chilling effect on the cyber industry? People might not want to become a CISO. They might not want to take on the responsibility of defending a corporation from, hackers from Russia and China and whatnot.
I have heard that. And the SEC brought a really impactful case against SolarWinds and its CISO last October, and that litigation is still ongoing. And that in particular, I think I heard from a lot of CISOs that this is their Enron moment. I mean, they were, scared to death and thinking that this is going to, cause good people to flee. It's too soon for that. And the litigation is ongoing. There's some interesting developments that occurred a couple of days ago.
What's the latest with SolarWinds?
The complaint, it was a big deal. Like I said, it's the first time the SEC ever sued a CISO. And one of the issues in that case was there were, in the SEC's telling of the tale, accumulating red flags, isolated intrusions, those added up, and the CISO should have escalated that to others in the organization, and the company should have told the world that because of these accumulating red flags and intrusions, the state of cybersecurity was so poor that some big attack was bound to happen. It was just around the corner, and the company didn't do so. And that's the SEC's allegations. A couple of days ago, in an oral argument, the SEC's lawyers made what SolarWinds and the CISO called an admission that one of the attacks that the SEC is hanging its head on is something, a red flag, wasn't really an attack or wasn't presented to SolarWinds or the CISO that way. That in fact, it was just a red team incident as reported by SolarWinds customer. So not an attack, but just something, a red team testing type situation. And so that's a big deal, actually. They're saying that it casts, doubt on the rest of the SEC's allegations. They're asking for exacting scrutiny to be applied to all of the SEC's claims.
Have there been any other sort of major news breaks of people who are in the crosshairs of the SEC?
There have just today. I think 3 hours. Fortunately enough, before I sat down in this chair, I think we got a press release from the SEC saying that ICE, so big exchange, paid $10 million in a settled action for not telling the SEC in a timely enough fashion about a cyber intrusion. Different set of rules. They didn't get the 4-day grace period. This was something called Reg SCI, so it's a different regulation. But under that rule, because it's an exchange, ICE was required to immediately notify the SEC of intrusions that they could not rule out as being de minimis right away. In fact, ICE waited 4 days, according to the SEC's press release, and so then had to pay this $10 million penalty. So.
How is the $10 million penalty determined? Do you have any insight into that?
They try to benchmark it compared to other precedent. So they do try to have some consistency. Has to do with, I think, how egregious. I mean, if I just sort of sum it up in a nutshell, how egregious does the SEC think this was?
Yeah, and then I'd be kind of curious if you thought, SolarWinds is a company, and of course they're important to IT and they manage a lot, but the New York Stock Exchange is the New York Stock Exchange. That's where all half of the public companies or so on, are going there. You think they might be trying to make an example of them?
I do. I think the SEC looks whenever it can to bring message cases. So if it's a really high-profile actor, that's bound to get more attention, and they have limited resources too, and so they pick and choose their cases and pick the ones that they think have the best messaging capability.
So one of the things I love about government regulation is there's always unintended consequences, right? So the SEC put these rules forward, and we actually had a hacking group report their incident to the SEC. What did you think of that?
I'm not surprised, actually, right? These are really mercenary groups. It was Black Cat, notorious ransomware group, and they hacked into someone, and the victim is a publicly traded company, did not file an 8K disclosing that there was a material cyber incident. And Black Cat said, well, fine, we're going to tell the world that we have now filed a complaint, a tip to the SEC, using the SEC's online reporting portal. It's called a TCR portal. Anybody can go on the website and submit this form online, but they took a screenshot. Black Cat took a screenshot of their tip, and then they put it out there for the world to see and said, look, this is what we did. We think that Black Cat was in violation of SEC reporting rules because they didn't put out an 8K saying that they were the victim of our attack. Is the SEC, they could have done it and called themselves a whistleblower. That's not going to fly, right? The SEC pays whistleblowers sometimes for submitting tips. Not going to happen here because Black Hat has unclean hands. But I think this is probably happening more often than we realize. The SEC keeps mum about tips it gets. Black Hat just decided to tell the world through screenshot that they had done this to get their message out. They too want to send a message. We'll use this as leverage to make you pay our ransom payment.
So with a potential ransomware group outing you, with a potential SEC doing fines, and a potential company that might not want to do everything they can to protect cyber, what advice do you give for CISOs, right? Should CISOs have personal insurance, liability insurance, protection? What kind of advice can you give there?
Yes, I think they should absolutely look to get some kind of insurance coverage. It's a dangerous world. There's more legal exposure and risks for CISOs than ever before because, lots more threat actors. There's an aggressive plaintiff's bar and regulators who are looking to get their message out too. So I do think they should. Sometimes if they can get covered by D&O insurance, that's great. Oftentimes the D&O insurance policy does not cover them. Maybe they can explore whether a separate rider is an option. If you can't get coverage that way, I think maybe there's some kind of indemnification policy separately you could negotiate with the company, but you should absolutely look to do that. And companies hopefully will look to provide that. I think if they don't, CISO really has to think, is this the kind of place where I'm going to be supported, or that company really cares or wants to invest in cybersecurity? So
I don't think Catton does this, but should CISOs get a second opinion from their own lawyer versus, the company's lawyer that might be like, oh, we got you covered?
I mean, if they can afford to do that, sure. I mean, I think hopefully if you can take the representation by the company that, you are covered. I don't know. I don't know what form. I mean, if it's just don't worry, we'll make good on this later. You're not actually covered. You could really be up a creek if that's, in that situation. So then
let me ask you this, because, the SEC is asking for all sorts of disclosures. And, on one hand, as a cyber expert, we kind of know we're never done, right? I'd love to say that the airplane's safe and we can't crash it. And a lot of times in IT, there's always one more thing we could do to make things a little bit better. So ultimately, the board, the executives have to sign off on that risk, and the CISO is always going to ask for more threat intelligence, another layer of defense, more authentication, that kind of stuff to enable the business. How can they go about getting buy-in and documenting the sign-off that, hey, they've presented the plan and the board has accepted the risk of how they're doing IT?
That's a good question. And I guess there are a couple ways to answer that. I mean, it makes me think of what's the form of communication you're using and the actual, messaging channels and what would be an appropriate way to do it. You probably want to be more formal here if it's not in minutes. I mean, it's just something more formal than probably your really casual messaging platforms. I know people do that, and that we can get into that too. And does that play a role, in a breach situation? What's the best way to talk to one another? But I think also just to take it a step back, a CISO should be hopefully educating all the senior leadership. They're a senior leader too. You want to educate the non-tech people and hopefully get company buy-in. And that's a really good thing. That education isn't a one and done thing. It's not a one-time training. You're educating people all the time about an evolving threat landscape. And you get, hopefully, by virtue of education, you get people with skin in the game. They buy into a plan. You minimize your downtime if an incident does happen because you've had a lot of smart people looking at this and buying into a plan. And I think as a not only a defense attorney, as an enforcer, I was always looking at how many people knew about this company process or set of processes. Whether it's impairment testing, like an arcane, accounting concept, or a cybersecurity governance procedure. You want to think about how many people at the company knew about this, because it's much harder for any regulator or even litigant to make a case that something's intentionally fraudulent if a lot of people know about it. If it's a closely held secret, I think that's where people can get into trouble. So you want to educate and get buy-in wherever you can. And then I think, maybe there's another thing we can talk about with messaging platforms. But
before we get to that, like one of the things I've been lucky enough to come to some board meetings and just give my thoughts on cyber and see some of the things I've seen done effectively. I want to get your opinion on this. Is people present it in terms of a budget, right? Like the bigger companies, they're not going to the board with firewall rule changes, right? They're going with procurement changes and policy changes, and then they're kind of showing that, look, if we do X, Y, and Z, it'll reduce the risk in these areas, but we'll still have these other areas of risk, and they kind of present it as that plan. Most CISOs I know never kind of go up and basically deliver the message, "Hey, we're good. I'm good," or we had 1 million events and we stopped 999,000 events and only a few others. So how do you feel about tying it to like the budget cycle or the normal business cycles of larger companies?
I mean, I think that can be really useful. A CISO could, ask for the absolute platinum plan. And that's what they're going to want, but maybe for cost constraints and other reasons, a company can only do the silver plan. But hopefully all of this is documented, and the reasons for not doing the Cadillac plan are documented in a way that's defensible for everybody, that the decisions were reasonable, that were made at the time. So when there's an incident, because it's probably when, not if, that you've got all that sort of on the record, and everybody's protected there.
And on the record in board minutes, board notes, that kind of stuff.
Could be, yeah. I mean, you got to be careful about how much detail you put into that kind of thing. But yes, but just sort of, good defensible, record keeping about like the choices that were made and if they were reasonable at the time.
Now, what if it's not that situation and the CISO, doesn't have a great relationship with the board, doesn't have a great relationship with the CEO, the CFO, that sort of thing, and hey, I'm just slacking the CEO, really asking, hey, I need 10% more budget. I need to switch from an MSP to an MSSP so we can get inspection on our home, whatever the reason is. And that's all done over Slack, and it's not really official business stuff. What are the issues with that kind of situation?
I mean, Slack and all the Teams, the messaging features, like all those messaging platforms make me nervous for a lot of reasons. I think some of them have disappearing features. They can be deleted. They're not always captured as part of the company's formal record keeping system. I think the messages can be edited. That's a problem maybe for the integrity of the evidence. Spoliation when there's data loss. It's not a great format for those kinds of conversations and those messages that a CISO wants to convey to the CEO. I do think it could play a role. I just think because it's, practical. If you're in a crisis situation and there's a breach ongoing, there's going to be constant communication, I think, between the CISO and the other leaders and the board. And maybe, but you're going to be meeting in all sorts of, maybe there's quick situational updates via that messaging platform and try to migrate it in later to the record keeping system. Also, caveat, the SEC is really active in bringing what's called off-channel communications cases. So if you're a certain type of regulated entity, you have rules out there that business communications need to be on a firm platform. So just be careful that whatever messages, quick messages in a breach situation aren't, if you're one of those entities, they're not on your personal device or outside of sanctioned channels.
Let's double click into that. So, if you have official communications is like Teams and email, Microsoft email, and then during an incident, people are using Signal, or they're just using text messaging, on BYOD phones. What should they do in that case? Should they, be working with a breach coach? Should they be working with, should they have official alternate communications established ahead of time? What have you seen there?
Yeah, I mean, those kinds of things could be all sort of part of the planning in advance, so that you know how you're communicating in the midst of a crisis. Yeah, I mean, Signal's a problem for the regulators and litigants because the messages just disappear.
Really good security is hard to regulate, right?
Yeah. Now I'm now in a position of collecting data and producing it to government regulators. And I mean, I was not too long ago asking for text messages and things like that. And so it's really intrusive, though, and invasive for employees. And just it's sort of costly to say, look, now we need your phone and you got to hand it over and we got to collect that too and produce it to the government.
So I'm expecting most of our viewers are listening to this conversation and thinking that it applies to public companies, SolarWinds, Citibank, the big regulator. But what about like a small tech company that's on their Series C round of fundraising? If they have a breach, could the SEC be coming after them?
Possible. Possible. Private offering frauds, if somebody's selling what the SEC can call a security, and pretty much everything can be deemed a security. It's an investment contract. You can call it a security. If the SEC thinks there are misrepresentations there to investors, they too can get caught up in the crosshairs of the SEC. And the SEC has at least issued subpoenas, and it takes testimony from third parties who are not regulated. They're not public companies. They can talk to individuals. They can put them in chair. They can ask for their data. It happens all the time. And so third parties can be a great source of data, sometimes data belonging to public companies. Think, your service firms, your accounting firms, your law firms. And the SEC has absolutely gone to battle with some of those third-party service providers.
So what kind of advice do you give a CISO or somebody actually more precisely who wants to become a CISO? They hear about all this regulation. They've got to stay ahead of the threats. They've got to stay ahead of all these policies, ahead of all the technology. What are you telling people who aspire to that situation?
I mean, I think it's a great field. It's an exciting field. You can talk to that. You're the best person to speak to that. So I think there's a lot of opportunity. Take heart. I mean, it's a great field. There's lots of great certifications out there. You can probably name them off the top of your head. I can't. That's
NACD, the Digital Directors Network. There's a lot of really good things out there. But let me ask you this. I'm going to put you on the spot here. So you're a lawyer. Lawyers are right up there with doctors. People who are esteemed professionals, and there's this culture of respect and stuff. What do you think cyber has to do to kind of get that level of awareness in the public and sort of that trusted advisor role?
For better or worse, every day we all pick up the newspaper, look at our phones and see all the headlines. And so just having cyber as part of everybody's sort of daily dialogue now, I think we'll get there pretty quickly. It's a newer field. It's a growing field. I just think we'll get there quickly. And there are many people out there who, there's a reason why they're C in the CISO title. It's a C-level executive. They're C-level executives and senior leaders, just like all the others with C in their title.
Excellent. All right. So how can people find you? What type of clients are you taking? Where do you work out of? Thanks for coming on the show.
Thank you so much for having me. And if you would like to find me, happy to talk to anybody if we can help. I'm at a full service firm, but like I said, my specialty is helping companies and governments, companies and individuals navigate government investigations. It can be the SEC, but most of my cases also had a criminal component running alongside of it. So other agencies as well. So enforcement is my specialty. I'm in the Washington office of Catton, Muchin Rosamond. It's 1919 Pennsylvania Avenue. You can look me up on the web, Danette Edwards. Firm bio is the easiest way. Send me an email, danette.edwards@catton.com.
I'll definitely put that in the notes. And we spoke at a private Catton event, but then you also spoke with Cindy Gula and Liz Wharton at ShmooCon 2024. So you want to do more public speaking, that sort of stuff?
Absolutely.
Awesome. Yep. Well, thank you again for coming on the show. I'm Ron Gula. I hope you enjoyed that. And if you want to hear more great interviews like this or get more contact, definitely give our video a like and follow us on LinkedIn. Thanks again one more time, Danette.
Thank you, Ron.
Have a great week.